Hello everyone, my name is Alex Lane and I'm one of the lawyers here at Lane, Hupp and Crowley. And today I'm going to talk about unlawful discharge. So unlawful discharge is when you have a firearm, and I'm going to just read it to you exactly, occurs when a person with criminal negligence discharges a firearm within or into the city limits of any municipality, and they are less than 1 mile from any occupied structure. So then that kind of raises the question, what does criminal negligence mean? And I'm going to read that to you. Criminal negligence means with respect to a result or to a circumstance described by any statute. So that would mean with respect to discharging the firearm, the person fails to perceive a substantial and unjustified risk that the result will occur, and the result being the discharge. So in law, there's a concept we talk about, the bad hand and the bad mind, meaning not every time a firearm discharges within a municipality or into a municipality as defined by the statute, within 1 mile of a occupied structure, it's not always a crime. In order for it to be a crime, right, that's the bad hand, the discharge of the firearm, you also have to have a corresponding bad mind, meaning you have failed to perceive an unjustified risk. So most of these cases, when I get called on these cases, most of the time, it's not somebody who's discharged the firearm into the air or something like that. It's usually somebody, there's been a discharge in somebody's home or somebody's apartment, something like that. I mean, obviously a firearm should never discharge within your home or within anybody's home, unless there's some justification to do so under attack, self-defense, that kind of thing. But if you're alone with a firearm, it shouldn't discharge. The question then is, how are you handling the weapon immediately prior to and during the discharge? So, for example, there are cases where people are cleaning their weapon or something like that, and obviously gun safety should play a role anytime that you handle a firearm. And something certainly probably went wrong, but occasionally, with the number of firearms we have here in Arizona, if you have enough people possessing enough firearms, it's quite possible that someone who is not creating an unjustifiable risk or failing to perceive one, a firearm could, in theory, discharge anyway. And that brings up an important point about whether or not to make a statement to the police. Generally speaking, a lawyer will tell you that you should exercise your right to remain silent and consult with a lawyer ahead of time. And that is particularly important in a case like this, because in order for you to be charged with a crime, they have to match the event that occurred, the discharge of the firearm, with what was going through your mind and what you were doing immediately before then. It's the state's responsibility to prove, it's their duty to prove, if you go to trial, beyond a reasonable doubt, both that the firearm was discharged, that it was in a municipality or fired into a municipality, plus they need to prove that what was going on in your head or the way that it occurred was actually that you failed to perceive an unjustifiable risk. How will they know that? They will know that based on what you say about what you perceived or not, and you have the right to remain silent. That's guaranteed in our Constitution. So anyway, that's unlawful discharge. And it's a public service announcement. Please be very careful with firearms. So again, it's Alex Lane with the law offices of Lane, Hupp and Crowley explaining unlawful discharge, and glad you stopped by. Thank you. And feel free to call us if you have any questions. And in particular, if you just discharged a firearm, you probably better call us. Thank you very much. Bye-bye.